Hi, and welcome to Bar 10 Test Prep, where we help you prepare for the bar exam and your law school classes 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so that you can be updated every time we upload new content. Let's get started with question number 1. Spender owed Midas $1,000 plus interest at 8% until paid on a long overdue promissory note, collection of which would become barred by the statute of limitations on June 30th. On the preceding April 1st, Spender and Midas both signed a writing in which Spender promised to pay the note in full on the following December 31st, plus interest at 8% until that date, and Midas promised not to sue on the note in the meantime. Midas, having received some advice from his non-lawyer brother-in-law, became concerned about the legal effect of the April 1st agreement. On May 1st, acting pro se as permitted by the rules of the local small claims court, he filed suit to collect the note. Assuming that there is no controlling statute, is the April 1st agreement an effective defense for Spender? A, yes, because Spender's promise to pay interest until December 31st was consideration for Midas's promise not to sue. B, yes, because the law creates a presumption that Spender relied on Midas's promise not to sue. C, no, because there was no consideration for Midas's promise not to sue, and that Spender was already obligated to pay $1,000 plus interest at 8% until the payment date. Or D, no, because Spender's April 1st promise is enforceable with or without consideration. Take 10 seconds. If you chose option A, yes, because Spender's promise to pay interest until December 31st was consideration for Midas's promise not to sue, you'd be right. Consideration is the bargain for exchange between parties. Consideration is present anytime promises with value or performances are exchanged. Any legal detriment or forbearance, as well as actual benefits and performance, can constitute consideration. Taking an action that a person was already legally obligated to do is not new consideration, however. The legal detriment or forbearance must be new to be valid consideration unless it is an addition or change in performance, unforeseen difficulty, or a third-party promise to pay. Any addition or change in performance is in fact new consideration. In this case, Spender and Midas's new agreement on April 1st created a change in their performance as compared to the original promissory note. Spender's new promise to pay the note on December 31st plus interest until that date means more interest has time to accrue than if Spender paid the debt earlier per the original promissory note. Midas's new promise not to sue on the note until December 31st means Midas gives up the right to sue on the note prior to June 30th per the original promissory note. Their changed performances constitute valid consideration for their new promises. Midas will not be allowed to file suit to collect the note prior to December 31st. As such, the April 1st agreement is an effective defense for Spender because Spender's promise to pay interest until December 31st was consideration for Midas's promise not to sue, and there is in fact a valid agreement as such. Question number 2. Roberta Monk, a famous author, had a life insurance policy with Drummond Life Insurance Company. Her son Peter was the beneficiary. Roberta disappeared from her residence in the city of Metropolis 2 years ago and has not been seen since. On the day that Roberta disappeared, Sky Airlines Flight 22 left Metropolis for Rio de Janeiro and vanished. The plane's passenger list included a Roberta Rector. Peter is now suing Drummond Life Insurance Company for the proceeds of his mother's policy. At trial, Peter offers to testify that his mother told him she planned to write her next novel under the pen name of Roberta Rector. Peter's testimony is A, admissible as circumstantial evidence that Roberta Monk was on the plane. B, admissible as a party admission because Roberta and Peter Monk are in privity with each other. C, inadmissible because Roberta Monk has not been missing more than 7 years. D, inadmissible because it is hearsay not within any exception. Take 10 seconds and choose the best answer now. If you chose option A, admissible as circumstantial evidence that Roberta Monk was on the plane, you'd be correct. Remember, hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Out-of-court statements not offered to prove the truth of the matter asserted are not considered hearsay. Here, Peter offers to testify that his mother told him she planned to write her next novel under the pen name Roberta Rector. This statement is not being offered to prove the truth of the matter asserted, so it would not be considered hearsay and would be admissible as circumstantial evidence that Robert Monk was on the plane. Question number 3. While Patty was riding her horse on what she thought was a public path, the owner of a house next to the path approached her, shaking a stick and shouting, "Get off my property." Unknown to Patty, the path on which she was riding crossed the private property of the shouting owner. When Patty explained that she thought the path was a public trail, the man cursed her, approached Patty's horse, and struck the horse with the stick. As a result of the blow, the horse reared, causing Patty to fear that she would fall off. However, Patty managed to stay on the horse and then departed. Neither Patty nor the horse suffered bodily harm. If Patty brings an action for damages against the property owner, the result should be for A. Patty for trespass to her chattel property, B. Patty for battery and assault, C. The defendant because Patty suffered no physical harm, or D. The defendant because he was privileged to exclude trespassers from his property. Take 10 seconds. If you chose B, Patty for battery and assault, you'd be correct. The general rule is that a person may use reasonable force to defend their property. The owner of the property must first make a verbal demand to desist or leave unless it reasonably appears that the request will be futile or that violence will occur immediately. Assault is the intentional creation of reasonable apprehension of imminent harm or offensive conduct. Battery is an intentional infliction of a harmful or offensive conduct with victim's person. The victim's person includes anything the victim is holding, touching, or connected to. Here, the defendant approached Patty while shaking a stick and shouting, "Get off my property." It did not reasonably appear that the defendant's request would be futile when Patty explained that she thought the path was a public trail. So the defendant was not justified in using force in defense of the property. The defendant then struck Patty's horse. The defendant clearly had intent to strike the horse, and Patty was riding the horse, so the harmful contact with the horse counts as harmful contact with her. Based on these facts, the defendant committed battery against Patty. When the defendant struck the horse, the defendant was likely aware of substantial certainty that the horse would rear and cause Patty to be afraid of falling off the horse. Patty was reasonably apprehensive about an imminent harmful contact with the ground when the horse reared. Based on these facts, the defendant committed assault against Patty. Therefore, if Patty brings an action for damages against the property owner, the result should be for Patty for battery and assault. Question number 4. Under the rule allowing exclusion of relevant evidence because its probative value is substantially outweighed by other considerations, which of the following is not to be considered? A. The jury may be confused about the appropriate application of the evidence to the issue of the case. B. The evidence is likely to arouse unfair prejudice on the part of the jury. C. The opponent is surprised by the evidence and not fairly prepared to meet it. Or D. The trial will be extended and made cumbersome by hearing evidence of relatively trivial consequence. Take 10 seconds. Choose what you think is the best answer. If you chose option C, you'd be correct. The opponent is surprised by the evidence and not fairly prepared to meet it. The court has the discretion to exclude relevant evidence if its probative value is substantially outweighed by unfair prejudice, confusion, or waste of time. Here, only C is not included in the court's discretion to exclude relevant evidence if its probative value is substantially outweighed by unfair prejudice. B, confusion, A, or waste of time, D, thus C, is the best answer. Question number 5. Which of the following items of evidence is least likely to be admitted without a supporting witness? A. In a libel action, a copy of a newspaper purporting to be published by a defendant newspaper publishing company. B. In a case involving contaminated food, a can label purporting to identify the canner as defendant company. C. In a defamation case, a document purporting to be a memorandum from the defendant company president to all personnel printed on defendant's letterhead. Or D. In a case involving injury to a pedestrian, a pamphlet on stopping distances issued by the State Highway Department. Take 10 seconds. If you chose option C, you'd be correct. In the defamation case, a document purporting to be a memorandum from the defendant company president to all personnel printed on defendant's letterhead. The rule is that every item of non-testimonial evidence must be authenticated. The following items are considered self-authenticating, so authentication is not necessary. Certified copies of public documents, acknowledged documents, official publications, newspapers and periodicals, business records, and trade inscriptions. In this case, answer choice C would be the item of evidence least likely to be admitted without a supporting witness. The item of evidence in answer choice A is a newspaper, which is self-authenticating. The item of evidence in answer choice B is a trade inscription, which is also self-authenticating. And lastly, the item of evidence in answer choice D is an official publication, which again is also self-authenticating. The item of evidence in answer choice C, however, is a document purporting to be a memorandum from the defendant's company, president to all personnel, printed on the defendant's letterhead, which is not self-authenticating because this is not a business record. As such, C is the item of evidence least likely to be admitted without a supporting witness. Question number 6. The state of Rio Grande entered into a contract with Roads, Inc. for construction of a 4-lane turnpike. Prior to commencement of construction, the legislature, in order to provide funds for parks, repealed the statute authorizing the turnpike and canceled the agreement with Roads, Inc. Roads, Inc. sued the state to enforce its original agreement. In ruling on this case, a court should hold that the state statute canceling the agreement is A. valid because constitutionally the sovereign is not liable except with its own consent. B. valid because the legislature is vested with constitutional authority to repeal laws it has enacted. C. invalid because a state is equitably estopped to disclaim a valid bid once accepted by it. Or D. invalid because of the constitutional prohibition against impairment of contracts. Take 10 seconds. Choose the best answer now. If you chose option D, invalid, because the constitutional prohibition against impairment of contracts, you'd be right. State or local government interference with government contracts is subject to strict scrutiny, meaning the law is unconstitutional unless it is necessary to achieve a compelling governmental interest. In this case, the state of Rio Grande entered into a contract with Roads for construction of a 4-lane turnpike. The state then repealed the statute authorizing the turnpike and canceled the agreement with Roads, thus interfering with Roads' contract. There is no evidence that canceling Roads' contract was necessary for the park's funding, since funding could likely have been obtained elsewhere. Moreover, funding a park is probably not a compelling governmental interest. The state's interference with Roads' contract does not pass strict scrutiny. Accordingly, a court should hold that the state statute canceling the agreement is invalid because of the constitutional prohibition against impairment of contracts. Question number 7. While driving his car, plaintiff sustained injuries in a 3-car collision. Plaintiff sued the drivers of the other 2 cars, D1 and D2, and each defendant cross-claimed against the other for contribution. The jurisdiction has adopted a rule of pure comparative negligence and allows contribution based upon proportionate fault. The rule of joint and several liability has been retained. The jury has found that plaintiff sustained damages in the amount of $100,000 and apportioned the causal negligence of the parties as follows. Plaintiff, 40%, D1, 30%, and D2, 30%. How much, if anything, can plaintiff collect from D1? And how much, if anything, can D1 then collect from D2 in contribution? A, nothing, and then D1 can collect nothing from D2. B, $30,000, and then D1 can collect nothing from D2. C, $40,000, and then D1 can collect $10,000 from D2. Or D, $60,000, and D1 can collect $30,000 from D2. Take 10 seconds. Choose the best answer now. If you chose option D, you'd be right, $60,000, and then D1 can collect $30,000 from D2. Remember that under the general rule, where there's joint and several liability, the plaintiff can collect from one defendant all funds, and then that defendant would be responsible for seeking contribution from the other defendants. Question number 8. Ted frequently visited Janet, his next-door neighbor. Janet was separated from her husband, Howard. Howard resided with his mother, but jointly owned the house in which Janet resided. Late one night, Ted and Janet were sitting on the bed in Janet's bedroom, drinking, when Howard burst through the door and told Ted, "Get out." When Ted refused, Howard challenged him to go outside and fight it out. Ted again refused. Howard then pulled a knife from his pocket and lunged at Ted. Ted grabbed a lamp, struck Howard on the head, and killed him. Ted is charged with murder. On a charge of murder, Ted should be found, A, not guilty because Ted had as much right as Howard to be in the house. B, not guilty because Howard attacked Ted with a deadly weapon. C, guilty because Ted's presence in Janet's bedroom prompted Howard's attack. Or D, guilty because Ted's failure to obey Howard's order to leave the house made him a trespasser. Take 10 seconds. If you chose option B, not guilty because Howard attacked Ted with a deadly weapon, you'd be right. Remember, a victim may use deadly force in self-defense if the victim is not at fault. The victim is confronted with unlawful force, and the victim reasonably believes that they are facing imminent threat of death or great bodily harm. Here, Howard burst through the door and told Ted, "Get out." When Ted refused, Howard challenged him to go outside and fight it out. Ted again refused. Howard then pulled a knife from his pocket and lunged at Ted. Since Ted was a non-aggressor victim who Howard attacked with a deadly weapon, Ted was justified fully in using deadly force in self-defense and should be found not guilty of murder. Let's look at the other options. A, not guilty because Ted had as much right as Howard to be in the house. This is in essence irrelevant because the question turns on the issue of violence and the self-defense, not the right to have been present. Option C, guilty because Ted's presence in Janet's bedroom prompted Howard's attack. Again, irrelevant. There is no act of violence. The act of violence is on the part of the decedent, not on the part of the guest. And option D, guilty because Ted's failure to obey Howard's order to leave the house made him a trespasser. Again, D is not appropriate because simply because an individual is a trespasser does not grant another individual the right to attack him with deadly physical force. So as a result, B is the best answer. Question number 9. Peter and his adult daughter Carmen encountered Tertius, an old family friend, on the street. Carmen said to Tertius, "How about lending me $1,000 to buy a used car? I'll pay you back with interest 1 year from today." Peter added, "And if she doesn't pay it back as promised, I will." Tertius thereupon wrote out and handed to Carmen his personal check, payable to her for $1,000, and Carmen subsequently used the funds to buy a used car. When the debt became due, both Carmen and Peter refused to repay it or any part of it. In an action by Tertius against Peter to recover $1,000 plus interest, which of the following statements would summarize Peter's best defense? A, he received no consideration for his conditional promise to Tertius. B, his conditional promise to Tertius was not to be performed in less than a year from the time it was made. C, his conditional promise to Tertius was not made for the primary purpose of benefiting himself. Or D, the loan by Tertius was made without any agreement concerning the applicable interest rate. Take 10 seconds and choose what you think is the best answer now. If you chose option C, his conditional promise to Tertius was not made for the primary purpose of benefiting himself, you'd be right. Under the statute of frauds, a promise to answer for the debt of another person if the debtor doesn't pay the debt must be in writing. However, this rule does not apply when the main purpose of debt being guaranteed was to benefit the guarantor. In this case, Peter promised to pay back Tertius the $1,000 loan if Carmen doesn't pay it back as promised. This is a promise to answer for the debt of another person, so under the statute of frauds, it must be in writing to be enforceable unless the primary purpose of the debt being guaranteed was to benefit Pater. As such, Pater's best defense would be that his conditional promise to Tertius was not made for the primary purpose of benefiting Pater, because if this is true, then this promise would have to be in writing to be enforceable under the statute of frauds. Question number 10, our final question in this grouping. The state of Aurora requires licenses of persons who are engaged in the trade of barbering. It will grant such licenses only to those who are graduates of barber schools located in Aurora, who have resided in the state for 2 years, and who are citizens of the United States. The requirement that candidates for license must be graduates of barber schools in Aurora is probably A, unconstitutional as an undue burden on interstate commerce, B, unconstitutional as a violation of the Privileges and Immunities Clause of the 14th Amendment, C, constitutional because the state does not know the quality of out-of-state barber schools, or D, constitutional because barbering is a privilege and not a right. Take 10 seconds now. If you chose option A, unconstitutional as an undue burden on interstate commerce, you'd be correct. If Congress has not acted, a state or local government may regulate local aspects of interstate commerce unless the state or local laws discriminate against out-of-staters or place an undue burden on interstate commerce. A state or local law that discriminates against out-of-staters is unconstitutional unless the law is necessary to achieve an important governmental purpose. Necessary to achieve an important governmental purpose means there are no reasonable, non-discriminatory means that would achieve the same objective. In this case, the state of Aurora requires a license for persons engaged in the trade of barbering, and it will only grant such licenses to those who are graduates of barber schools located in Aurora itself, and who have resided in the state for 2 years. This clearly discriminates against out-of-state barbers, and even if the state has an important government purpose, there are reasonable, non-discriminatory means that would achieve the same objectives. As a result, option A is your best answer. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time, so don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content for you.